Good evening, everyone, and welcome to tonight's webinar, Navigating Through Divorce and Custody Issues for Families of Children with Special Needs. My name is Kate Carr. I'm one of the family navigators here at the St. Louis ARC. Without further ado, I would like to turn it over to our panelists for their introductions.
I guess I can start. Hello, I'm Erin Rathjen Decker. I am the head of the family law team here at Sandberg Phoenix.
And I'm Josh Hutkins, and I'm head of our wealth planning team, which includes estate planning, guardianships, and special needs planning as well.
Okay. So just as an introduction to what we'll be talking about tonight, every family is unique on their, of all their circumstances, especially when facing a divorce. So as we talk through sort of what the system is able to do for you, how I try to prepare my clients is to tell them knowledge is your best protection. Understand what the system can do. And then also know that most of the best creative solutions occur outside the court. So while I'm a litigator by trade, settlement mediation allows me to be a whole lot more creative and to address things like what we'll be talking through later in terms of the estate planning piece to accomplish what your ultimate goals are with your family, with special needs kiddos, and how to put things in place for the future. So I tend to refer to it as a scalpel versus a sledgehammer, with the court being a sledgehammer. There's very little detail that can be included in some of the things the judge is allowed to do. So we will try and sort of talk through what that looks like. So there's the financial piece, what support is available for a family with a special needs child, and how a divorce judgment may impact your eligibility for those things. And then with the custody part of a divorce, how you can work within the statutes, and what Missouri provides for in terms of time with each parent before the age of 18 versus what a guardianship looks like after age 18. And just as a side note, I am licensed in Missouri only. So when I talk about the divorce law, it's Missouri statutes. Illinois is different. If I try and get into both states, we'll be here all night. So I'll be covering, when I reference law, it's Missouri. We have offices in Illinois, and I would certainly refer somebody to one of our specialists over there. But this presentation will be Missouri centered. So without further ado, I will let Josh go ahead and get started with our financial piece and the support available to families.
Thanks, Erin. So when we're talking about the financial piece and we're talking about child support payments and how it can impact the public benefits that your loved one is receiving, we first need to really figure out what type of public benefit we're discussing that your child is going to receive. So there are two main types of public benefits. You have those benefits that are based on or that are not based on financial need, and that would be your typical Social Security, your Medicare, as well as a couple other benefits. But then you do have public benefits that are financial need based, and that's probably what you hear the most of with a loved one with disabilities, and that is your supplemental security income, or your SSI, your Medicaid, food stamps, legal aid, as well as HUD. Public benefits in those that are most impacted by child support payments, we're really talking about SSI and Medicaid. So those are the two that I'm going to focus on the most, leaning more heavily towards SSI. And so when we're talking about supplemental security income, or SSI, we first have to understand what it is and how you become eligible for it. So SSI is a federal program administered by the states. So whereas Erin said she is licensed in Missouri, everything she says is going to be Missouri based, because SSI is a federal program. It's governed by the federal government. However, each state operates a little bit differently. Which means it's a mess. It can be chaos. But what I'm going to be specifically talking about is how it's administered in Missouri and how that relates with Missouri custody and Missouri child support orders. So SSI is based on the sufficient evidence of disability and financial need. I'm going to assume that the disability component has already been met, and we're not even looking at that. So we're just talking about financial need for this workshop. SSI is intended to pay only for the beneficiary's food and shelter and nothing more. So if you are receiving SSI, please understand that it can only be used for your loved one's food and shelter, nothing else. And then in order to qualify for SSI, you have to pass 2 tests. The first test is the resource test, which determines eligibility. And the second test is the income test, which is going to determine how much SSI your loved one is going to receive every month. The easy way of remembering the 2 tests is to think about a door. So the resource test, once you pass it, is what's going to unlock the door. If you can't pass the resource test, which I'll talk about in a second, the door is going to stay shut, it's going to stay locked, and you will not be eligible to receive those public benefits. Once you pass the resource test, the door becomes unlocked, and then we look at the income test to determine how wide that door's open, to determine how much of that benefit you can receive every month. So resource test unlocks the door. The income test is what's going to open or close that door depending on how much income you're receiving. Now, before your child or loved one turns the age of 18, it's highly unlikely that they will qualify for SSI or Medicaid. The reason being is while they are a minor and under age 18, the Social Security Administration looks at mom and dad's or mom's or dad's resources to determine eligibility. And so as you'll see when we get to the resource test, it is a very low threshold. So that's why I say it's highly unlikely that they would ever receive it prior to them turning 18 years old. All right, so in order to determine what the resource test is, we first have to understand what is a resource. And it says a resource is anything that can be converted into cash for support. And so if resources for SSI eligibility exceed $2,000 on the first day of the calendar month, you will not pass the resource test and you will not qualify for SSI. Now, Medicaid is a higher threshold. It's right around $5,000 for 2024. But I don't want you to think I have 2,000 here and 5,000 over here. In order to qualify and maximize benefits, you need to stay under the $2,000 because SSI is what's going to basically be the most important for you for that food and shelter. And so, as I said, if the child is under the age of 18, we're looking at moms and dads resources. Chances are they exceed $2,000 of resources, so they won't qualify. But after a child turns the age of 18, we're only concerned about their assets. So on their 18th birthday, basically it clicks, we're looking at what they own. And what I would highly recommend is trying to ensure that if you are going to need to apply and qualify for SSI or Medicaid, that your child, your loved one, does not have any assets in their own name. And when we talk about guardianships, that's going to be a big key as well. So what is an exempt resource? So the Social Security Administration has provided that a home, if the individual has ownership interest and it is their principal residence. So if they own a home and they live in it, it will be an exempt asset for SSI and Medicaid purposes. But do understand that while it is an exempt asset and it won't disqualify them from receiving SSI or Medicaid, Medicaid does have the ability to attach a lien to that house. And if they've received Medicaid benefits during their lifetime, Medicaid will be paid back upon the sale of that house or upon their passing. So while it does allow you to qualify, it's not a perfect avenue. And then if they own the home, but they have to be moved to a long-term care facility or a group home, because it's no longer their principal residence, it's no longer an exempt asset. Household goods under $2,000, really, Social Security Administration has better things to do than determine who owns the couch, who owns the TV. So it's highly unlikely they look at that, but it is stated as a $2,000, under $2,000 is exempt. They could also have a burial plot. And then one automobile is completely excluded regardless of its value if it's used for their employment, medical treatment, or it's necessary for them to get around. And then another exempt asset is a life insurance policy with a total face value less than $1,500. So it's a very, very small life insurance policy. Other exempt assets that you've probably heard about and are considering would be an ABLE account. So this is a bank account that is created to allow the disabled loved one to have a little bit of income, but be able to put that into this ABLE account so that they can continue to qualify for public benefits. So that it doesn't eat away at their access. But an ABLE account, again, is not the perfect plan. It's just a tool that should be used. ABLE accounts do have a maximum amount that can be contributed every year. So in 2024, that number is $18,000. So your loved one or you can contribute up to $18,000 without causing any public benefit disruption. But the ABLE account also has a cap of $100,000. So if your ABLE account goes over that $100,000 cap, the whole thing will be counted against you, will be counted as an asset. So you have to ensure that that never exceeds $100,000. Now, the other type of resource that is exempt that we think would be the gold standard would be a special needs trust. There are two main types of special needs trusts. One is called a first party or a Medicaid payback trust, and the other is a third party. The big difference is first party is funded with the disabled individual's assets, whereas the third party special needs trust is funded with a third party's assets. So that would be like mom and dad, grandma, somebody creating this trust for their benefit, and it then gets funded from their assets. So that would be part of, typically part of mom and dad's estate planning. And so if we go on, once we pass the resource test, again, we've unlocked the door. So now we have to determine how wide that door is going to be open. And so we have the income test. And the Social Security Administration breaks income into three separate categories. You have your unearned income, which would be gifts that your disabled loved one receives from family members. It could be payments from annuities, pensions, support. So child support is going to be deemed unearned income. You also have dividends, interest, as well as payments of other benefit programs. Other benefit programs would essentially be if they are also receiving Social Security disability income. Then you have your earned income, which is your typical W-2 wages. And then you also have in-kind support. So that would be receiving food, clothing, and shelter. And the reason in-kind support is going to affect the amount of SSI you receive, because as I mentioned, SSI is only there to pay for food and shelter. But if you are receiving food and shelter from some other resource, i.e. mom or dad, then what SSI is going to do is they are going to reduce your SSI basically dollar for dollar of the in-kind support that you are receiving. And so, really for the rest of this workshop, I'm going to assume that we passed the resource test and that all we're really focused on is keeping that door open as wide as possible. Okay. And so if we look at child support, as I mentioned, child support is going to be deemed unearned income. And so what the program operations manual or POMS, which you've probably heard of, what they state is that when an eligible child receives child support payments, those payments are deemed unearned income to the child. They will reduce the amount of SSI benefits they receive. Now, the Social Security Act does have this 2/3 rule. And it says, basically, if an absent parent, which is just a parent who is paying the child support, they may be involved in the child's life, they may have joint custody, but when they say an absent parent, they are talking about the parent paying support. So when a parent is paying support, 1/3 of that support will be deemed an exempt asset, whereas 2/3 of it count as unearned income to the child, which again will lower, or if that child support just continues to accumulate, it will then disqualify them and we fail the resource test and lock the door. What's more likely to happen is that the door won't be locked from child support payments because mom or dad or guardian is using it for their benefit, so they're constantly spending it down. But what's going to happen is it's just going to slowly close the door to where it might get shut depending on how much child support payment mom or dad is paying at the time. Okay.
I was just gonna say, in terms of how child support is determined in Missouri, it's available in divorce cases, paternity cases, modifications, third-party custody actions, or with guardianships. FSD, which is the Family Support Division through the state, can determine it through an administrative action, or it can be court ordered in a circuit court action, which would be like a divorce, paternity, and modification. In Missouri, we have what's called the Form 14, and that is the presumed correct amount for child support. You input gross income, there are credits for things like health insurance, daycare, school costs. There's a custody credit, and through some sort of mathematical witchcraft, they come up with a number that is deemed by the state to be the presumed accurate child support amount. So the judges do have discretion to either go up or down, depending on the circumstances surrounding the case. But that's if you're in the circuit court. If you apply for child support through an administrative action with FSD, FSD will not deviate from the Form 14. So the Form 14 will be the number. So just, kind of going back to that idea of trying to work outside the system, you can find the Form 14 online and sort of run numbers and see sort of the range, given the number of children, their custody, credit, things like that, and get an idea of what that support number would look like for a family. And just know that in the circuit court, you have the ability to deviate either up or down based on other circumstances, direct pay for some of the kids' activities and things like that. So just to jump in on how support is calculated. And it looks like we have some questions. I don't know if now is a good break time.
Yeah, we have a few questions. One is there a way to make sure child support continues after a non-custodial parent retires?
Well, retirement in and of itself does not change the child support. What the court looks at in a modification is what is the change in circumstance. So if retirement means that the employment income is different, the court can still consider all financial resources available as a resource for paying support. So if someone has retired, chances are they are not now at zero income, whether it's a 401k, whether it's Social Security, whether it's some other income source. The court can consider that for payment of support. It may mean rerunning the Form 14. I would also caution that a voluntary reduction of income through something like retirement gives the court the ability to impute back at the rate that the payor was earning at the time they elected to retire. The idea being you understood your familial obligations when you elected to retire. If you were paying $1,000 a month in child support and said at age 62, well, I'm all done doing that, so I'm going to retire and not pay anymore. The court can say, well, you still have the ability to earn that job. And we find that pretty often because the judges can work until age 70. So if you're under 70, they tend to not like you walking away from work. So I hope that kind of answered that question.
And then when child support is determined, do they pay any more if one of the children is disabled?
And that kind of goes to that ability to deviate from the Form 14. There is not a standard that says, given medical needs or therapy needs or something like that, you're going to have an automatic uptick in the support number. But those additional factors can build in to either be added to the Form 14 to boost the number, or there can be direct pay arrangements, like everybody's going to split therapy costs, or medical expenses will be paid 70-30. Those additional things can be part of a decree so that it's not the monthly support number, but they are paid elsewhere. If the concern is that only the monthly support is paid, I would encourage someone to add it to the chart as a necessary extraordinary expense so that the monthly number is boosted, because you get additional benefits from the state to chase support around. The state FSD can be aggressive in pursuing unpaid support. They cannot go after the sort of additional things like, someone hasn't paid for childcare or hasn't paid for therapy or hasn't paid for doctor's visits. They don't have a firm number to work with. So it becomes a question of how locked in is your judgment number if you need the state's help.
Yeah, I do see this one about making changes to an ABLE account once the child turns 18. Basically, I mean, there's nothing you really need to do on that. If they are working and they're putting their own money into it, they can be added to the account and have control over it if they're able to. But they're not gonna. It's not like a forced thing to do. So once we understand that child support is going to be paid, and again, we don't want to have a reduction of benefit, and we don't want to potentially fail the resource test and have that door locked, we would say that, again, the gold standard would be to have a special needs trust. And as you can see, a special needs trust is a way to provide private funds to a loved one with disabilities in order to maximize their ability or their access to public benefits. And a well-structured special needs trust, third party or first party, can provide financial security for the life of the individual. What I mean by that is if a loved one receives $1 million in a properly drafted special needs trust, that will not impact their public benefits one way or the other. And so they can receive as much as an inheritance, or in this context, child support, without having any impact on their public benefits. Now, in the context of divorce and child support, we are talking about a first-party special needs trust, and the special needs trust must be approved by the court. So when you're working with your divorce attorney, and you have a disabled loved one, you would have that first party special needs trust prepared, and it would become part of the divorce decree. Now, there are two main types, as I mentioned, of special needs trust. Third party, where they're funded by somebody else's money. And then the big difference is that there is no Medicaid payback provision, and that it cannot be funded with child support. Whereas a first party, also known as the self-settled special needs trust, is funded with the beneficiary's money. And child support, because it's their unearned income, is deemed to be the beneficiaries or the disabled child's money. It's their income. So that's what would fund that first party special needs trust. So if you already have Aaron, if you go back real quick, sorry.
Yep.
If you already have a third party special needs trust because you've created it as part of your estate plan, but then you are going through a divorce and there's going to be child support, it's almost a certainty that you would need both the third party as well as the first party to receive those child support payments. And again, the big difference is it does have that Medicaid payback provision, which means that if the beneficiary passes away and they receive Medicaid benefits during their lifetime, Medicaid is the first payee, the first beneficiary upon your loved one's passing. If any money is left over, then you do get to determine where it goes, but Medicaid is first in line to receive repayment for any Medicaid benefits they received during their lifetime. All right. So then we have the elements of a special needs trust. And special needs trust is drafted specifically so that the trust assets are not considered an available resource and that they don't impact that resource test. So the door always remains unlocked. The Social Security Administration says that it must be a discretionary trust in which the trustee has the full discretion on when and how to make distributions. And so nowhere in a special needs trust should it say that the trustee shall make a distribution to the beneficiary. It should always be purely discretionary, and it should really be very broad in what it does allow for, as long as it follows certain rules. And certain rules being that it is there for only the benefit of the disabled beneficiary, where this trust cannot be used for siblings, cannot be used for anybody other than the beneficiary themselves. And then if the beneficiary has no discretion over the distributions, again, they can't demand a distribution from the trust. It will not be counted for SSI eligibility, and that the funds in the trust are there to be used to supplement public benefits, but not supplant. So as I mentioned, in-kind support, if the trust allowed the trustee to make distributions for food and shelter without first exhausting the SSI benefit, then there would be a reduction dollar for dollar in the SSI benefit received. But every properly drafted special needs trust should say that it's there to supplement but not supplant, meaning I am going to use their SSI money for food and shelter before I ever use the trust money to pay for those expenses. Now, fortunately or unfortunately, SSI only pays, a certain amount, and it's more than likely not enough to cover their food and shelter. So the special needs trust can end up paying the difference between what their rent is, what their food expenses are. It can pay the difference versus what SSI is paying. So the next elements of a special needs trust is that the clients, when creating it, they are the grantors, the ones who create it, but then you have to determine who is in charge of the trust. And so in most cases, mom and dad may both be in charge, may both be trustees, but it's possible that if dad is paying child support to mom, that mom wants to continue to be able to be solely in charge of that trust. And that's where, you would work with both your estate planning attorney as well as your family law attorney to negotiate those terms, right? Or, if dad's paying child support to mom, can mom be solely in charge of it? Or is dad going to pay child support, but both of them are going to be in charge of the trust? Both of them can see that the money's being used properly. That's just something for your whole team to discuss. The trust will, as I mentioned, will also provide how and when the funds can be used. And then a third party trust, you get to determine where the money goes after the disabled loved one passes away. And typically it would go to other siblings. It might go back up to mom and dad, but you get to make that decision. And then with the first party or Medicaid trust, again, Medicaid goes first, but then you do get to decide those beneficiaries if there's anything left over. So some common pitfalls we see in judgments or settlements is that you have a disabled child and that there is no provision for what happens with child support once they turn 18. Again, before 18, child support can be paid directly to mom, directly to dad, whoever the custodial parent is, and you're not going to impact public benefits because we're not concerned with public benefits. We're not going to apply because we're not going to pass the resource test. But good forethought, good planning would say, hey, once your loved one turns 18, the judgment would basically create this first party trust, or at least provide for the payments to the first party trust. But more often than not, and Aaron will get to it, we end up having to do these modifications because there was no planning in place. Other pitfalls we see with judgments are unstructured beneficiary designations, which would be IRAs, 401ks, life insurance, where the divorce decree might just say, hey, that goes to the kids. Well, if it goes to the kids and one of them is disabled, we're going to fail the resource test almost immediately. With unstructured beneficiary designations on retirement accounts, 401ks, IRAs, life insurance, those can specifically name a third party special needs trust for that child. And so you don't have to worry about the Medicaid payback provisions because that money was never theirs from the get-go. We can basically name the third party special needs trust. We also see that a parent might be required to fund a 529 or a college savings account. Well, if you remember the exempt resources, a 529 account was not named as an exempt asset. So if the divorce decree requires a parent to fund a 529 account, that's going to disqualify them from ever being eligible from receiving public benefits. We also potentially see a disinheritance where we say, hey, because our loved one's receiving public benefits, or they're going to need public benefits, I'm going to disinherit them so that way whatever support they would receive, they'll never get. Well, it's sort of counterintuitive. They're going to need the money more than anybody else, and we've just drafted this decree, this judgment in a way saying that they won't receive any additional support. So disinheritance, I think, is really the worst way to go because, again, they are going to need that additional support for the rest of their life. And so you can get around that by doing a special needs trust and having whatever inheritance or whatever support they were going to receive go into that special needs trust. So one of the questions was, how does child support affect special needs trust? What changes do we need to make once my child turns 18? So again, child support in and of itself will not impact a third-party special needs trust, but you cannot direct child support payments into the third-party special needs trust. So you will have to create that first party and then work with your family law attorney to get it into a first-party special needs trust. So it remains an exempt resource. Have you seen issues with one of the parents misusing the funds in the child special needs trust, worried about X having access to son special needs trust or even ABLE account? If you are co-trustees of this trust, even though you are their parent, you also owe them a fiduciary duty to use those funds properly. And if you are a co-trustee, you have the ability to, have access to all accounts, see how the money's being used. And if there is, a legitimate issue with misuse of funds, you essentially try and get them to remove themselves as trustee. If they won't remove themselves, you can file an action with the court to remove them for basically breach of fiduciary duty. So if there is a true issue with misuse of funds, it's something you have to act on pretty quickly so it doesn't go any further.
Well, I can move on to
Yeah.
how we get those support payments in there. There's no statutory authority in Missouri that allows for payment to a trust. So it becomes one of those, it has to be a creative solution and settlement where we build into the decree the obligation to make the payment to the trust. Missouri law provides only for payment to a person with custody. So if you go through FSD, which I discussed earlier, the administrative action, they cannot make that requirement, which may lead you to a modification down the road, which we will get to, but it can be done fairly easily. So the language in the decree has to specifically state the support recipient's name and state that the payment of the support obligation shall be made to the irrevocable trust for the benefit of the child, and that prevents the inclusion of the support amount as income. So that's, and I have an example in here that we will get to. Oh, here you go. The petitioner shall pay his monthly support amount for the child and the amount directly to the irrevocable trust. And then the respondent consents and agrees to the payment of said child support obligation to the trust. So that's what you're looking for in the court in order to make sure that you don't have an issue later with the receipt of benefits. The child support parameters in Missouri allows for, and this is just under the statute, 18 or 21 if the child attends college. You can extend child support beyond age 18, and the statutory language is if the child is physically or mentally incapacitated from supporting himself and insolvent and unmarried. So what I encourage parents to do is as your child approaches 18, if there is a support order already in place, you need to be back in court to address the 18, the termination, before the child is emancipated, which is what happens at 18 if they are not attending higher education, in order to get the additional support provision, and so that it states it shall continue past the normal age of emancipation due to the child's physical and mental disabilities and inability to support himself. So that's your second judgment if it is not there originally. If the first time you were coming to court, if the divorce is happening when your child is already over the age of 18, that would be part of the original judgment that says, you know, this child is not going to be emancipated at 18 or 21. It will continue indefinitely due to, you know, the child's inability to support themselves. So all that would be included in your judgment. And at that time, if the child's over the age of 18 at the time of the dissolution, then the trust immediately becomes the recipient. You're never going to be in a modification situation. Your original judgment would include the trust as the payor. For children under the age of 18, I recommend one of these provisions that you either create the trust at the time of the child's 18th birthday, or the trust is drafted but not funded until 18. And Josh, I don't know if you want to cover what that looks like, just having an empty trust.
So, I mean, basically, you know, if you're planning ahead for this scenario when they turn 18, you can create the trust, you know, years in advance. What I would say is don't go out and get a tax ID number for it. Once you get that tax ID number, you're technically supposed to file an income tax return, a 1041 for it. Now, obviously, with it being unfunded, it hasn't earned any income, and so you can file a zero return. But you can create it at any point, and it would just sit there as a piece of paper. You don't create the account for it until it is going to be funded, and it would only be funded upon the child turning the age of 18. At which point, that's where the child support payments would go.
So upon the 18th birthday, that's when you have the language about paying to the trust directly, and that avoids the need for a modification in the future. If your decree does not include that language and you have, you know, a kiddo turning 18, then you'll need to come back on a modification in order to direct the payment to the trust. So these are additional points that you can consider as part of that judgment if you're trying to build out future planning. You know, who's going to pay the attorney's fees to get the trust drafted if it's not already done? Who's going to be the trustee? How are funds going to be allocated in the event of the child's passing? Are you going to build in language about decision making for the child? So the original decree can deal with a lot of the things that may come up in the future if it is drafted carefully, is always my recommendation. So with modification, let's say you got divorced when your kiddo was 12, and now suddenly you're down the road and he's turning 18, you need to deal with the trust, you need to deal with modification. If you don't have anything else to modify, if you're not changing the amount, you're not changing Anything other than where it is going in order to keep eligibility for benefits, then a consent modification is the easiest way to proceed. And Josh and I have done several of these together to keep it low cost and low paperwork for clients. We work together on getting the trust drafted, and then it's referred over to me for filing a modification case. And in Missouri, you can file a consent modification. We request that the court allows you to file it without financials. For those of you in domestic cases, you know that the initial filing includes like a statement of property and a statement of income and expenses. It's intense and a lot of paperwork. We can get an order that allows us to skip that piece. And because it's a modification and not a divorce, we can file basically the motion that opens the case and then the judgment almost simultaneously. So we tell the court we're modifying, and then immediately behind it, we file the new parenting plan Part B, which is the support piece in Missouri, and the Form 14. And even if you're not following the Form 14, if you're finding that the presumed amount is unjust and inappropriate, you still are required to file it just to tell the court this is what, you know, the Form 14 says it should be. And then you have this new exhibit is the piece that tells the court and FSD and anyone else in charge of child support that the payment is now going to the trust. And so again, none of it works if someone's looking for a new support amount, that would require the filing of the financials. It becomes a contested case, like a regular modification. Now, if someone is seeking a modification of the support amount and it is going to be a contested case, the end result can include payment to the trust. But you are not going to be able to move through it with this sort of consent judgment process. That's really quick and easy.
And real quick, if the parties want to consent to a reduction or an increase in child support for whatever reason, can that be processed just as quickly?
Yes, that can. Thank you for jumping in, because the consent part is what's important. If everybody agrees that support should go from, you know, 500 to 1,000, knowing that it's going to be paid into the trust, you can just build that part into Part B. It is the consent that's important. If there is going to be a discussion, if the parent paying support is paying 500 and the person receiving support says it should be 1,000, and the payor is like, oh no, thank you, then you're going to need to file the financials and actually take it in, and they'll either recalculate the Form 14 or it will be contested basically. So you have to do all of the things that you have to do in a contested case. With more than one child in a family, you have to be clear with how the support is being allocated. With the Form 14, your kiddos are not weighted equally in a support amount. So like if you have 3 children and the support amount is 1,500, it is not 500 per child. There are fixed expenses that go into that mathematical witchcraft. So your first kiddo has the bulk of the support cost. And so you need to allocate very carefully in your judgment how the support amount for the special needs kiddo is going to be paid to the trust. What is that amount? Is it reducing with the emancipation? Is it set? There's a lot of pieces with that. And here's the Form 14. It looks like a nightmare. You can see at the bottom, the 3 children number is 1338. 2 children number is 1155, and the 1 child number is 811. So clear right there. That's what I mean by it is more heavily weighted to the 1 child. So as an example, here you have the portion. If your special needs child's the oldest, his portion is sort of shifting as the other children are emancipated. So if the other 2 emancipate, now his number is 811. So you can build into the order that you want the support for him paid into the trust. And it will be 183 if there are 2 other children unemancipated. It will be 344 if there's only 1 other unemancipated, and it will be 811 when the other 2 are fully emancipated. That's a lot. That's a lot of moving pieces. That's a lot of sort of uncertainty and timing. Or you can agree that it's not pursuant to Form 14 and there's a specific number that you're going to pay into the trust, it doesn't change with the emancipation of other siblings. And that you can do it this way by either by child, like it's 1338 for 3, and so we're going to divide it equally, and it's going to be 446, because the Form 14 doesn't give you that option. You can do it on your own. You can tell the court this is what we've decided. So it's 446 per kiddo, and as they emancipate, 446 drops off for each one. As long as the total amount is due, your judgment remains enforceable. So you consider whether you're looking at the total amount of support to be subject to modification, or whether it's per child, because if you have to come back, that's what the court's going to look at. Is if you did 446 and we emancipated one kiddo, is that remaining number of 446 times 2 still an applicable number? Or are we going to modify just per child? Or you set a number for your special needs kiddo, and then you say it's 1338, 300 is what we're designating to the trust for the benefit of that child. The other $1,038, I made that math hard for myself for some reason, is what's going to keep going directly to the parent. And that may be because there are other kiddos in the home. So one thing that makes this tricky is if you have shifting amounts and emancipating kids. I mean, this whole thing is tricky, but if you have shifting amounts with emancipating children, you may end up in a situation where you have payments going to a trust and then payments going to the custodial parent, and the FSD record for payment doesn't sort of match up. Like, we know it should be 1338. Mom is getting a payment for $1,038. Where's the other 300? So to draw it back together for FSD, if they ever come calling, and some of that depends on if you're paying through the state. What I do is I build in an obligation on the custodial parent to sign up here. You have to, there's a credit affidavit where you can acknowledge receipt of those additional funds and say, yeah, it's fully paid up. It just didn't come through the state because it went through the trust. Basically, it's an obligation to acknowledge the full amount has been paid. Income withholdings, which is a process by which the state withholds support from someone's paycheck. These can be an absolute nightmare if you have multiple kids, because they cannot make 2 payments. So Josh and I went round and I went round and round. I don't know, what was it, 7, 8 times with the clerk and the state, and so we were ready to pull our hair out. In those cases, if you have one payment that is going to a trust, you can designate the withholding to the trust. That's easy. It's if you have, custodial parent is to get $1,000 and trust is to get 300, the income withholding sort of blows up. So it will end up coming to the custodial parent, who then has to make the transfer. So that's the way you deal with an income withholding. So yeah, and that's another one where the affidavit of credit, that's what I was talking about with, in order to catch up FSD records. If FSD suddenly reaches out to the non-custodial parent and says, all right, it looks like you're behind $300 a month, that's where you can have this affidavit, the requirement to execute it. So that then they just tell the state, no, I got this money, it's fine. These are the income withholding forms. They are available through FSD. They're available through all of the county court systems. Again, the court they're difficult and likes to reject them. So if you need help, I encourage you to reach out to one of us. So we sort of walk you through that process. Are there additional support questions before we kind of jump into the custody piece?
Do modifications require parents to be present in court? Basically concerned about the kid having to be present and everything else. If it is by consent, so we're doing a divorce modification by consent, it can literally all be done via paperwork and filing. So it does not require you to be present. If, however, it is a contested modification and, because you guys agree on, hey, the child support payment needs to go to the trust. Everybody agrees on that. But we are disagreeing on whether child support needs to be lowered because, hey, they're gonna be receiving public benefits. I feel like I should be paying less. Well, if there's not agreement on the child support function or the amount, that would require court appearances. And as Aaron mentioned, because we're now talking about the amount being paid, that would require to file financials, and you do get it sort of back into the dispute you may have had during the initial divorce proceeding. So by consent, all done by paperwork, no court appearances are required by either party. If it's contested, it would require court appearances, and it would be a much longer drawn out endeavor. If the child with disability remains their own guardian after 18, are they considered emancipated or unemancipated? So if a disabled individual and you don't seek guardianship of them, and the divorce decree prior does not provide for continued payments, then as Aaron mentioned, when they turn 18, if they don't go to school, then yes, they would be deemed emancipated.